Hello everyone, my name is Keerti Karmuse. Today I am going to explain about the topic registration of partnership. In this topic, I am going to cover the meaning of the partnership deed, aspects included in the partnership deed, why it is necessary to register a partnership firm, what will be the consequences if we don't register, then we will understand the procedure to register a partnership firm, and at the end the advantages and the disadvantages of the same. Let's begin. Meaning of partnership deed. Partnership deed is nothing but agreement between the partners of the firm. This is done to avoid the misunderstanding among the partners in the future. Now, let's see what are the aspects included in the partnership deed. In order to enter into a partnership, a clear agreement with respect to terms, conditions, and all aspects concerning the partners is essential. The written agreement which specifies the terms and conditions that govern the partnership is called partnership deed. The partnership deed generally includes the following aspects: name of the firm, nature of the business and location of the business, duration of the business, investment made by the each partner, distribution of profit and losses, duties and obligations of the partners, salaries and withdrawals of the partners, terms governing admission, retirement and expulsion of a partner, interest on capital and interest on drawings, procedure for dissolution of the firm, preparation of accounts and their auditing, and method of solving disputes. Now, let us understand why it is so important to register a partnership firm. According to Indian Partnership Act 1932, governs the partnership, registration of partnership firm is optional and it can be done at any time before starting of the business or at the mid of the business. It is always advisable to register the firm since a registered firm enjoys special rights which aren't available to the unregistered firm. Let's see what are the consequences of non-registration of a firm. It is optional for a partnership firm to get registered. In case a firm does not get registered, it is deprived of many benefits. The consequences of non-registration of a firm are as follows. A partner of an unregistered firm cannot file a suit against the firm or other partners. The firm cannot file a suit against the third parties, and the firm cannot file a case against the partners. Let's understand the procedure for the partnership of the firm. First, application for registration. Partnership firm can be registered by sending an application in form number 1 along with the form requisite fee and a true copy of the partnership deed also needs to be sent to the register. Such an application needs to be filed with the register of firms of the area in which business is located. Thus, the application must outline firm name and nature of the business of the firm, place or principal place of the business, names of other place where business is undertaken, date of joining of each partner, full name and address of the firm, duration of the firm. Further, such an application must be signed by all the partners or agents who are specially authorized to do so on their behalf. Also, it must be sent to the registrar within a period of 1 year from the date the formation of the partnership firm. Second, verification of application for registration. Each partner signing such an application must also verify the same in the manner as suggested under the Act. Next, documents to be attached to the application for registration. Following other documents along with the prescribed fee must be submitted to the registrar, which includes registration application in form number 1, duly filed affidavit, certified and true copy of partnership deed. It must be noted that Partnership deed created by the partners must be on a stamp paper as the Indian Stamp Act, or the deed must be on a stamp paper that is applicable in the state in which such a deed is implemented. Rental or lease agreement or proof of ownership of place of a business. Next, fee for registration. As per Section 71 of the Act, the state government is free to make rules regarding the fees to be given to the registrar along with the other documents for registration. Next, naming a partnership firm. The name of the partnership firm should consider the rules mentioned in the above section while choosing a name of the partnership firm. However, the firm so registered must use brackets and the word registered after its name. Further, if any partner is not satisfied with the order of the registrar with regard to the firm name, he may appeal to the person authorized by the state government in this behalf. This appeal must be done within 30 days from the date of the communication of such an order and on the payment of the requisite fee. The authorized officer on receiving the appeal would make the decision in this regard. And at the end, entry of the statement in a register. Finally, as per section 59 of the Act, the registrar makes an entry of the statement in a register called the Register of Firms and files the statement. This is undertaken after the register is satisfied that the application of registration complies with all the necessary provisions. The date on which the registrar records and files the statement is considered as the date of registration of the partnership firm. Now, let's look towards the advantages after registering of a partnership firm. First, easy formation. Registration is not compulsory in the case of partnership firm. Even the registration of a firm is optional, hence no longer formalities are required. Thus, they are simple and economical to form and operate. Next, flexibility. A partnership firm is a flexible organization. At any time, the partner can decide to change the size or nature of the business or area of its operation. There is no need to follow any legal procedure, only the consent of all the partners is required. Larger resources. Due to more number of members, the partnership firm has large resources for the business operations as compared to the sole proprietorship. Decision making. Each partner has the equal right to participate in the management of the business. Partners share the decision making and can help each other out when they need to. More partner means more brains that can be picked for business ideas and the solving of problems that the business encounters. Sharing of risks. Risks does not fall on one individual shoulder in this type. It is shared by all the partners. Every partner bears the risks individually as it is easier compared to sole proprietorship. Greater specialization. The principle of division of labor can be applied to a great extent in a firm, which results in greater specialization. Now, let's see what are the disadvantages. First, unlimited liability. The liability of each partner is joint and several. The firm cannot conduct any large business activity. This is because if the assets of partner are insufficient to pay off the debts, then the personal property on partners is taken over the creditors. Limited capital. Since the total number of partners cannot exceed 20, the capital to be raised is always limited. It may not be possible to start a very large business in a partnership firm. Lack of continuity. A partnership firm lacks continuity because of death, insolvency, insanity, or retirement of a partner. Firm may come to end particularly when the partners are two or three. No legal status. A firm is not an artificial person like joint stock company. It is not recognized by the law as a person. The existence of the firm is related with the partners. The insolvency of the partners is the insolvency of the partnership. Risk of implied authority. Each partner is an agent of the firm. He can bind the co-partners by his activities. On account of this authority of the partner, honest partners have to suffer for the foolish, reckless, or dishonest actions of the partners. Hope you all have understood the concepts clearly. Thank you.